Hey, what's up everyone? This is Ben from Lavacat Law. Today I'm going to talk about the differences between joint tenancy and tenancy in common, which is a property law concept. Property can be held two ways. First way is as under a joint tenancy. When property is held under a joint tenancy, the co-owners do not hold it in shares, okay? They hold it as one unit. So for example, if A and B own a HDB flat or a condominium as joint tenants, they hold it as one, okay? So if one of the joint tenants dies, okay, the other automatically gets the property. So even if B makes a will and purporting to give away his share of the condominium of HDB to his friend, for example, or brother, mother, sister, it does not work because the property law concept of joint tenancy will prevail and override the will. So if A and B own a HDB flat as joint tenants, okay, and B dies, A will get it, okay? To give you another example, A, B, and C own a condominium as joint tenants. If C dies, A and B will hold it together as joint tenants. Okay, even if C purports to give it away in a will, it doesn't work. And then now the property is held by A and B. If B dies, A gets it. Then only when A becomes 100% the sole owner of the property, then it goes under his will, or if he dies without the will, then it will go to his family members under the Intestate Succession Act. Okay, the next concept I'm going to talk about is tenants in common. Holding property as tenants in common is holding it by percentage. For example, 50%, a husband can own 50% of a HDB flat or condominium, it applies the same, and the wife holds 50% of the HDB flat. It doesn't always have to be 50-50. It could be 30-70, it could be 20%, 80%. So, I repeat, tenancy in common is where joint owners, or not joint owners, where co-owners own property by percentages, okay? When a person owns property by percentages as tenant in common, he can give away his share under a will, okay? So if he owns, for example, 30% of a property as tenant in common, he can actually do up a will to give away his 30% to his friend, his family, to a charity, okay? If he doesn't have a will, a person who owns property as tenant in common, his share will go up to his family members under the Intestate Succession Act, okay? And for property held as tenants in common, the problem arises where, let's say for example, a husband and a wife own a HDB flat as tenants in common in the shares 50% and 50%. The husband does a will to give it to his brother or his friend. So after the husband dies, the friend or the brother will inherit 50% of the HDB flat, which is a bit difficult because now the wife has to live with someone she probably does not know, okay? So she has to either buy over the share so that the person who inherits the share can get the money, or they have to sell the HDB flat so that both can get their monies, okay? Now, I will go back to the concept of joint tenancy. Joint tenancy, as I've said, is where two or more persons hold property as one unit, okay? What happens if the co-owners don't want the doctrine of survivorship, which is when one dies, the other automatically gets it? What happens? What he can do is to do what is called a severance, which is to cut the joint tenancy in two so that it becomes tenant in common. So if, for example, a brother and sister own an HDB flat as joint tenants, and they don't want the doctrine of survivorship to apply, which is when one dies, the other gets it, they can go HDB, fill up a form to cut it in two, okay? 50%, 50%, or 30%, 70%, 20%, 80%. For private property, you need to sever the joint tenancy by signing a document in front of Commissioner of Oaths. Okay, that will cost about $200 to $300. So that's all I have to say today about owning property as joint tenants or tenants.